I was watching the Alex Murdough hearing this morning, and as I was watching the procedures and seeing how everything was done in that courtroom, it got me thinking about, hmm, every state has different laws about whether or not they're going to allow videos in the courtroom. And in fact, there's not really laws per se, but it is a matter of the judge gets to decide. But what's the difference between public being able to view a trial and too much publicity that it may sway some jurors? That's the question of the hour. This question is not going away anytime soon. There are so many people that are interested in true crime and they want to see trials as they happen. I think that back when we were watching the O.J. Simpson trial, we got to see it live, and there's been some other high profile trials that we were able to watch live. And now there's kind of a little bit of a, should we change that? Should we start making these trials closed? And I would love to hear your opinion. Let me give you both sides of this argument. There's two examples that I'm going to use today. The Lorivallow trial, which was no cameras in the courtroom until the sentencing. And then at the sentencing, it was one camera scanned way back. The visibility was, well, I'm just going to say it, terrible. And then you have Alec Murdough trial where they actually let court TV come in with their cameras and microphones and film. Still not perfect, but a lot better because the cameraman can zoom in, zoom out, and kind of get a feel for the courtroom, and you really have a lot better idea of what is going on and who's saying what and who's attending and all of those things. I love it. But I am a journalist and I want to see, I want to know. And that's the whole point. But I also can understand the arguments a little bit about not creating mayhem. I was thinking about it, and in fact, my opinion about this has changed just this week. And that's because of the Ruby Frankie court that's going on. It's an ongoing battle, but let me just put it this way. There was a child custody hearing based on the fact that mom, Ruby, is in jail and dad has been, it's been 13 months since they've been together. Mom had been taking care of the kids completely, and now we have to decide where's the safe place for these children, right? Well, I wanted to go to that court case and I was planning on trying to go, and I've been looking and looking and trying to find, like, when is it? When is the next hearing? When will this be? And then I realized, it dawned on me, these are small children, underage. It's one thing if the over 18-year-old children, Ruby and Kevin, come out and they have their own YouTube channels, and that is a different story. But these underage children and what's happening in their case was supposed to be private. It was not supposed to be going out to the world. And the fact that a reporter from the Daily Mail was in the courthouse, and even though the judge said to keep the proceedings private, they reported on it. I talked about it in a previous post, and there's a lot of news that has been reported based on what the Daily Mail reported. And I'm sure all of them, as well as myself, did not know this was not supposed to be public knowledge. The fact that it was leaked after the judge said not to is deplorable. And I didn't realize that the judge had said, don't leak, all these things, because I wasn't actually in the courtroom. So as I was trying to find this court case, I realized, this is supposed to be private. I shouldn't be going in there, and I certainly shouldn't be reporting on it, because these children's lives can be ruined based on what the world is saying. And so for that reason, I'm sticking with the Ruby and Jody case in St. George. But okay, so let's get back to the point of this video, and that is when it's adults, children are a different story, but let's just, for today's sake, let's talk about adults. And there's trials going on. And again, I'm going to be using Lori Vallow and Alex Murdough as my examples. Alex Murdaugh's murder trial was televised. We got to see every single thing that was happening all along the way. And we could go to it. We could either go to it or watch it. And Lori's was completely the opposite. It was very hard and very tricky to even get into the courtroom. I tried for days, and you had to have a special, like, inside loop on how to get into that courtroom. I went in for one day and then I went to the sentencing. But the point is, and then finally at the sentencing, the judge allowed cameras in the courtroom, but still on a limited basis. It was just the camera that they provide, not a professional camera from a major network, and certainly not microphones. It was very hard to see and blurry and rudimentary at best.
State of Idaho plaintiff versus Lori Noreen Vallow, aka Lori Noreen Daybell, defendant, case number CR 22211624. Verdict. We, the jury, duly impaneled and sworn to try the above entitled action for our verdict, unanimously answer the questions submitted to us as follows. Question number 1. In regards to count 1 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception? Answer, guilty. Question number 2. In regards to count 2 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of first-degree murder of Tylee Ryan? Answer, guilty.
Because of my communications with my friend Tammy Daybell, I know that she is also very happy and extremely busy. I have always mourned the loss of my loved ones, and I have lost many in this mortal world. However, I know that more than most people. I know where they are now and what they're doing. I know how wonderful heaven is, and I'm homesick for it every single day. I know we all lived in heaven.
You took her life away. You destroyed that family, fractured it to the point where, in the information I've had through the PSI, there are relationships that will probably never be mended that have rippled as a result of what's happened. JJ and Tylee, of course, 7 years old, 16 years old, were separate people whose lives were cut way too short because of you. Never got to grow up and be adults. The family and friends who have provided their impact statements.
So here's my question. Do you think that people can get a fair trial even if it is public? That's the question of the hour. Now, I will say that the attorneys in the Alex Murdough trial that's coming up, not the murder trial, but the one about the false insurance claims that's coming up, they argued this. They talked about it, and I want to show you a little clip from that, and then we'll talk about it. In the case of Alec, they show everything from people filing into the courtroom, when the person who's on trial comes in. They show everything. I'm curious what you think about this.
I'm happy to read those numbers into the record. They are extensive. We have 2021 GS 4727 in Orangeburg County, containing a number of white-collar counts. 2021 GS 4728 in Bamberg County. That is a grand jury.
This case was finished 6 months ago. It clearly, I don't think anyone who disputes this had more publicity than any case in the history of this state, and maybe the country. On national television every day for 6 weeks, the motions hearings were covered and they're here again today. It has been...
Okay, I'm really not trying to sway you one way or the other, but how about this guy that walks up during the middle of the proceeding and takes a picture? Okay. All right, let's get back to this.
Podcasted, blogged, we've got podcasters out there who are ripping their 15 minutes and hanging by their fingernails, wanting more of their 15 minutes of fame and continue to talk about this. I understand one of the solutions to massive pretrial publicity is a change of venue. There are two cases I want to cite to the court, both of the United States Supreme Court cases, that indicate a continuance and/or a change of venue is required. Prejudice is presumed from pretrial publicity when pretrial publicity is sufficiently prejudicial and inflammatory, and the prejudicial pretrial publicity saturates the community where the trials are held. They found presumed pretrial publicity in a case much less renowned, much less publicized than this one. And Your Honor, to try this case in less than a year after the verdict came in the other case, don't we need to let it calm down a little bit? Where are you going to get a jury? Mars? I mean, there's nowhere in this.
Now, this judge is extremely different than the Lorivallow judge. In fact, he lets it be known that he believes that just because there's pre-trial publicity doesn't mean you can't get potential jurors. Listen to what he has to say.
Allendale, Orangeburg, Beaufort, Colleton, Hampton.
I appreciate your sense of humor.
It's not a sense of humor. We have many counties where these indictments were issued. I'm not presuming that a jury cannot be impaneled. Just as the trial that took place in Colleton County, there was no motion to change venue. And I'm not presuming any prejudice, and the test is not based on speculation. The test is whether or not a jury can be impaneled. You first have to attempt to get a jury according to the law.
What I'm saying is, I think it'd be an exercise of futility. I know this. We've been interviewing jurors, as you know, in the murder trial. There was a juror on this trial, and that, I'm afraid, is what happened on that jury. We've got a motion for a new trial for after discovered evidence. The Attorney General is going to file their response tomorrow. We believe the Court of Appeals will order a hearing before a circuit court judge to determine whether or not the clerk of court tampered with that jury. And that is and so we would go forward with another trial while that matter is pending, while that matter is being litigated?
Probably not in Colleton County.
Well, Your Honor, the idea that somehow something happens in Colleton County doesn't affect what happens in Beaufort County. This is a national case. I mean, do they not have television in Allendale County?
I don't know.
Do they not have the internet?
I don't know.
What's the hurry? That's the other point. What is the hurry? He's pleading guilty to state charges, but the state insists on doing them in serial so they get 3 convictions so they get life without parole. On a guy who's already serving 2 life sentences without parole. This is just another attempt to get more publicity, to make this another national case. And Your Honor, I'm offended that the Attorney General he's got many other cases that are much older than this, but granted, Court TV won't be there for them. This is another effort at creating a national spectacle. Now, Your Honor has some things to say about Mr. Murdough and his sentencing. You obviously believe he's guilty of that. You obviously, and the jury found him guilty of that. But I would ask you to put those feelings aside and give us a chance to really go through what's happening. I'm bewildered by this. Certainly they can do it, but why? Why? What is the hurry?
Your Honor, this isn't about a spectacle. These white-collar indictments have been investigated by the state just about 2 months after the side of the road happened. This is about allegations that represent an assault on the state judiciary. And because of that, they need to be answered. Your Honor is exactly correct that the law does not presume prejudice. If he wants to file a motion where he cites law, then we can respond, but the law is very clear. Is that you don't presume prejudice, you try to seat a jury. And only through that process can the court then assess whether or not a jury can be seated. We are in, that just leaves nothing left to happen. This is just the reality that we live in. And so we depend on the ability of the system, we depend on the ability of the jury selection process to seat jurors. And that is what should happen. And only if there is an inability to do so can this court then consider whether or not there needs to be some change of venue or some relief or something like that. That is exactly what the process should be. And this is a big county, this is Beaufort County, and fundamentally, just as we rely on lawyers, just as we rely on judges to be objective about what they do, and that includes the defense motion here, okay? We have an objective duty. We also depend, the system depends on jurors to be objective as well. And to just say, because there's publicity, nothing can be done, just throws the system out and leaves no recourse whatsoever. And what the defense can't do is try to essentially run down the street to the federal authorities and bypass the accountability that needs to happen in state court for a direct assault through use of a state law license on this courtroom, Your Honor, on the other courtrooms or the other counties that I named. The state judiciary needs, the state judicial system needs to answer for this the allegations of this assault. And that's why this is important. That's why this case has priority, and that's why the state seeks to move it forward.
Briefly, Your Honor.
Yes, sir.
Well, this wasn't his argument a year ago when he called the murder case first. The murder case was indicted after the financial crimes, and it wasn't that important then. Now, all of a sudden, it's, you know, the most important thing in the world. I would suggest, Your Honor, that he made a decision to try the murder case first, not the financial crimes, and as a result, we've been put in the position, you know, of where we're at today. In addition to that,
Your Honor, that is absolutely not what happened. I even said I was happy to try the white-collar cases first. It was the defense's motion for a speedy trial and Mr. Harpootlian's waiver of his legislative immunity, which is what led to the murder cases being done before. It was the defense that wanted to trial the murder case. They filed a motion for speedy trial, and the state said, okay, let's do it.
his decision to agree with that, Your Honor. It was up to him. He's calling the case today. The solicitor calls the case, the prosecutor. We don't call the case. It was his decision. He decided to go with the murder case first.
Your Honor, the state is happy to show up in court and seek justice for these very important matters whenever a date can be scheduled. And the only reason the murder went first was because of Mr. Harpootlian.
Well, the court's not going to defer to Texas in setting a trial date. And a trial date will be set prior to the end of this year.
Okay, they both have some pretty good arguments. And then I thought it was really interesting, the judge. And I'd love to hear what you think about what the judge said as far as this argument goes. If there's this much publicity, is there a way to get a fair trial? What do you think? And I guess it's just a matter of opinion. One judge on one hand believes absolutely no fair trial without having no cameras in the courtroom, whereas the other judge says we can find people who will comply with the law according to what is okay for a juror and still be able to have this be public. I'd love to hear your thoughts. Comment below and let me know your opinion. Should cameras be in the courtroom, or do you think they should be absolutely locked out? I'd love to hear from you, and I will see you again soon. See ya.